SJC-11374, Lightlab Imaging, Inc., v. Axsun Technologies, Inc., et al.
Good morning, may it please.
Hold it, please. We want to get you on tape, and Mr. Keneally has to handle that. All right, let's proceed.
Thank you, Your Honor. May it please the Court, my name is Kenneth Berman, and I represent Lightlab. The first issue I'd like to address is whether the judge overstepped her gatekeeper role to exclude evidence of Lightlab's damages. The second issue I'll address is whether the judge applied the wrong permanent injunction standard. Let me first, however, briefly give some facts established by the verdict, by the Chapter 93A findings, and by undisputed evidence. Lightlab had pioneered a unique medical technology called OCT that obtains images of the inside of human coronary arteries using very sophisticated lasers. The latest laser was jointly developed by Lightlab and Axsun. Volcano is a Lightlab competitor. It was behind in its OCT development and needed a laser to compete with Lightlab. Volcano couldn't get one anywhere, as no one else in the world could replicate what Axsun and Lightlab had achieved.
I know I'm interrupting you, but could you get us to where you were after the 2006 version of the? Yes.
The pre-2006, Lightlab was using a different type of a laser for its OCT system. That was a time domain laser. And after 2006, it determined that if it could use a frequency domain or Fourier domain laser, then it could actually accelerate the OCT system in order to be able to do an OCT procedure that would not require vessel occlusion. And that was a major objective of Lightlab. So in 2006, starting in 2006, early 2007, Lightlab partnered with Axsun to try to come up with a frequency domain laser that could do OCT. Axsun had not had previous experience building an OCT laser. Axsun was an industrial laser company, and Lightlab had considerable experience with OCT lasers. So they worked after 2006, in 2007, to develop this laser. They had developed a number of versions of the laser. By April of 2008, the parties had come up with the version 5 laser, and they had made a supply agreement and development agreement with respect to the version 5 laser. And then between April of 2008 and December of 2008, the parties worked together to come up with a version 6 laser. And at the end of 2008, the parties made a modification of their agreement to replace the version 6, the version 5 with a version 6. Volcano was not able to get an OCT laser, as no one else could replicate what Axsun and Volcano had done in developing an OCT laser. And the contract with Lightlab barred Axsun from selling lasers to Volcano. So instead of buying lasers from Axsun, Volcano bought the whole company. It bought Axsun to get the laser and to get Lightlab's OCT technology, as the judge found in her Chapter 93A findings. And it expropriated the scientific relationship that Lightlab had with Axsun, while intentionally misappropriating Lightlab trade secrets from Axsun in the process. In the liability trial, Lightlab won on all of its claims. The jury found there were contract breaches, tortious interference with both contract and advantageous relations, misappropriation of trade secrets under common law and statute, and unjust enrichment, while the judge found that Axsun and Volcano knowingly and willfully violated Chapter 93A.
But you wanted damages up to 2035, is that right?
2038, yes. And let me explain about that, the post-2014 damages. First, why are there damages? The judge cut off damages at April 28th, 2014, so we need
When
to...
the contract, the exclusive right ended at that point, correct?
Yes, that's when exclusivity ended, but exclusivity had nothing to do with Lightlab's damages theory. So we need to ask, why are there damages after April 28th of 2014? And I'll give the short answer. The wrongful conduct took away Lightlab's ability to get a version 7 laser and upgrade its OCT system with it. Some potential customers will inevitably wait for the next generation of a product before investing the capital to buy it. You have your round 1 customers who buy the initial version of the product, and then you have your round 2 customers who are the customers who will buy the upgrade. Because Lightlab could not innovate its system beyond the version 6 laser, Lightlab will be going into the post-2014 world with a smaller customer base than it otherwise would have had.
So would your cause of action lie against anybody who purchased Axsun if they deprived you of the ability to create version 7?
If they tortiously interfered with our relationship with our development partner.
Your
Yes.
post-contractual relationship?
No, it wasn't a contractual, they weren't contractually obligated to develop with us, but there was a development relationship that we had with them, and the jury found that there was tortious interference with the relationship.
How is that different from Axsun just collapsing, disappearing, and leaving you without any ability to develop a version 7 or generation 7 device?
Well, if that had happened, then, and if Axsun, for example, had gone into bankruptcy, then that would have been an unfortunate business result for Lightlab. But that didn't happen, and there wasn't any expectation that Axsun was going to be going out of business.
But after 2014, Axsun simply could have decided not to do business with you anymore, couldn't they?
They could have decided not to do business with us.
That wouldn't be a breach of contract or relationship?
No, actually, they couldn't have decided because we had a right to have our laser supply extended to 2016. We had a right to purchase lasers from Axsun until 2016.
But they could have declined to develop version 7 with you.
They could have, but there was no reason why they would have stopped developing with us during the period of the contract, because they had an exclusivity with us. They could only sell their OCT lasers to us. So it made the interests were aligned. It made no sense for Axsun to stop developing with us, because the better the laser became, the more OCT systems we could sell, and the more OCT systems we could sell, the more lasers they would be able to sell.
So did you work with Axsun up through the contract period, 2014?
We're not there yet.
Well, the development relationships stopped when Volcano purchased Axsun. They wouldn't develop with us any longer. Lightlab makes money not just by selling OCT systems to new customers, but by selling OCT catheters to the hospitals and the clinics who buy its OCT system. This is the classic razor blade business model. Once you have the razor or the system, you need to buy the blades or the catheters from the manufacturer, and each OCT procedure requires a new catheter. So the damages from selling catheters into a smaller 2014 customer base are very substantial, and they last well into the future, certainly beyond 2014. Weinstein
But
computed...
did you establish that you lost customers and opportunities up through 2014?
At the time of the voir dire, there wasn't any expectation that Lightlab would have lost any customers as of that point, because the version 7 laser wasn't anticipated until after the voir dire. We were getting the jury verdict established our right to get the version 6 laser, so we were selling customers who would buy the version 6 laser. Weinstein computed the post-2014 damages because the discounted cash flow methodology provides a way of doing that, and because the only time an expert wouldn't do that would be if it was expected that the business would come to an end at 2014, and that wasn't the case here.
But and I'm not, well, here's my basic question.
Sure.
The DCF method, fine, and no one disputes that, but you need a realistic base on which to build it, don't you? I mean, isn't that the problem, that sort of going out from 2014 to 2038 is entirely speculative?
No, it's not entirely speculative. Weinstein did not select 2038 as the damages period. He computed it. And by his calculations, the damages would taper out year by year until they end in 2038. The discounted cash flow method provides a way of determining when the damages will end. And it was his computation that it would end in 2038. So whatever the jury might think about 2038, we say it was clearly arbitrary for the judge to cut off damages on April 28th, 2014. The time-related basis that the judge gave was that it was error to assume that Lightlab would be the market leader until 2038. But neither Weinstein nor Lightlab ever made that assumption.
Did she cut off damages or just prohibited your expert from testifying to what he was going to testify about damages and the damage calculations?
It's the same thing. Without our expert to be able to testify as to the post-2014 damages, we're not able to get the damages after 2014.
So the president of the company, did he testify about damages? Who testified about damages?
There wasn't any testimony about damage.
You need an expert to testify about that?
Yes, we do. We need an expert to quantify the damages.
In this arena? I mean, there's no way that anybody could do it without that, you're saying?
What the CFO had done was he provided projections of the income and the lost income to the expert. But the expert has to take those projections and then apply the discounted cash flow methodology to those projections in order to come up with the damages. And case law says that you can't recover damages without discounting them to
Wasn't
present
the
value.
judge sort of focusing well, actually, she wasn't focusing on the validity of the projections, because she said I would have to have a voir dire of Clark, is that his name?
That's correct. Weinstein's testimony was not excluded because of any finding by the judge that there was unreliability in the underlying projections. The judge never reached that issue. She excluded Weinstein for reasons completely unrelated to the reliability of the underlying projections. But when damages stop and whether Weinstein's assumptions were appropriate are questions for the jury. All of Weinstein's work was disclosed on a year-by-year basis to 2038. The jury would have been able to adjust the damages if it felt, after listening to cross-examination, contrary expert testimony, closing arguments, that Lightlab's damages would end before 2038.
Can you help me as to what happened with regard to the subsequent voir dire? There's some reference about the CFO furnishing a somewhat, according to the judge, strange offer of proof, and also some mention the CFO refusing to submit to a voir dire.
It wasn't that he refused to submit to a voir dire. His voir dire became irrelevant. The sequence of events was that the judge had issued her order precluding Weinstein, with the exception of a small sliver of damages that she said Weinstein could testify to with respect to so-called reputational damages as to the system. We came to the conclusion that having a jury trial to be able to prove that small sliver of damages wasn't worth the time and effort because they were so insignificant. The significant damages, the damages that mattered, were the ones that the judge had excluded with her opinion. So we advised the judge that we wouldn't be going forward on trial with respect to this small sliver of damages, and therefore there was no need to conduct a voir dire of Mr. Clark. The judge did, however, say that we could submit an offer of proof in whatever form we wished, and we did that. So it wasn't that Mr. Clark refused to show up for his voir dire. The judge agreed with us that there was no point in going forward with a voir dire of Clark. That just would have been a waste of everybody's time. If I can touch briefly on the injunction issue. On trade secrets, the judge issued an injunction falling so short of what the circumstances warranted as to constitute an abuse of discretion. Axsun and Volcano are proven misappropriators. They had every motive to use all the information Axsun had gotten from Lightlab to make a competitive laser and OCT system for Volcano. Axsun was now under Volcano's control, yet the judge would not enjoin any more violations of Axsun's confidentiality obligations other than as to the secrets already proven to have been used, even though injunctions are meant to prevent violations of rights before they occur. There was a lot of back and forth in the briefs about what standard the judge applied and whether that standard was right or wrong. But the fundamental point is this. The correct standard is whether, under all the circumstances, a wrongful disclosure, use, or acquisition is sufficiently likely, such as to warrant an injunction. And that wasn't the standard the judge applied. The judge applied a secret-by-secret standard, not a totality of the circumstances standard, and would not issue an injunction to protect any trade secret that had not already been used. By any measure, the circumstances were such that Lightlab needed an injunction to protect all of its secrets and hold Axsun to its contractual commitment, which it had already breached, that it wouldn't use or disclose Lightlab's trade secrets and confidential information.
Could I ask you about, because there's obviously a dispute between you and the defendants about this intent to use, whether the statute requires intent to use or actual use. And you both seem to be reading, or you each seem to be reading the record very different, or what the judge meant very differently. So you want to give me your version of it?
Sure. When we had to offer evidence on trade secret items 1 through 5, we argued to the judge for a broader standard for injunctive relief, and that she should issue it if the circumstances indicated that the secrets were at risk. And we offered some evidence of Volcano's general intent to use whatever it could from Axsun. And the judge said, I find that regardless of this evidence, that there's no evidence that Volcano intended to use the trade secret items in items 1 through 5. So in other words, what she was saying was that we couldn't get a trade secret injunction broad enough to protect trade secret number 3 unless Lightlab could show that Volcano either used secret number 3 or had made a conscious decision to use that particular secret specifically. The defendant's behavior here was about as bad as one could imagine. It put Lightlab's business future and confidential information at serious risk, and the judge set impossible standards for the relief that should have issued, allowing the wrongdoers to escape unscathed. If these are the standards, this will have profound and troubling implications for universities, research partnerships, emerging technology companies, and the Massachusetts innovation economy. We submit that this court should grant the relief requested in our brief so that Lightlab can obtain a trial on its lost profits damages and meaningful injunctive relief.
Chief, could I
Thank you,
just ask
Counsel.
one question? Sorry. I thought, though, this is back to the intent to use or actual use,
Yes.
that you said that you were drawing a distinction between the 1 through 5 and then beyond that.
Yes.
And that with respect to the beyond that portion, that you read the judge as saying that it had to be actual use, not intent to use.
That's right, because the only issue at that point, Your Honor, was whether we were going to get an injunction to protect the balance of our trade secrets. She already had concluded that we couldn't get an injunction as to trade secrets 1 through 5. And so what the judge suggested in order to expedite the proceedings is that the defendants file a summary judgment motion on the use issue. They did file a summary judgment on the use issue. We submitted contrary affidavits, and the judge found that there was no use sufficient to warrant a permanent injunction as to those secrets. That's the only reason that there was that summary judgment proceeding
So
at
you
all.
read that as she wasn't even considering, I mean, besides the sort of looking at the broader issue, she also wasn't considering intent to use as part of the standard. Is that?
Right. In fact, we had moved for reconsideration with respect to her use ruling, and she said at the summary judgment hearing, I have already said that intent to use is not the standard. That's the law of the case. And then she said, I may be wrong on this. Appeals court, SJC, are you listening? I may be wrong. So yes, that was the standard she applied, and it was very narrow, and we were not able to get an injunction as a result. Thank you.
May it please the Court, my name is Bill Lee, and I represent Axsun Technologies and Volcano Corporation. At the outset, if I could, I'd like to focus on the 3 narrow issues that are actually at issue on appeal, because many of the facts that Mr. Berman's discussed actually don't go to the issues on appeal. So there are 3 issues, each of which is determined by the abuse of discretion standard. The first was the Superior Court correct? Did she abuse her discretion in excluding testimony about future lasers not yet invented, not yet designed, not yet developed, not yet marketed? The second was did she abuse her discretion? Was she correct when she excluded testimony about projected lost profits after the end of the contract period, which were predicated upon the presumption that every customer would buy a new laser every 6 years until 2038? And the third, and I'll come back to answer Justice Botsford's question about the injunction, did the Superior Court correctly conclude, did she abuse her discretion in concluding that the request for a very broad injunction was inappropriate? Now, when I said I'd like to focus on these 3 issues, let me come back to many of the facts that Mr. Berman discussed with you, particularly at the beginning and the end of his argument. This was a lengthy and complicated case. The Superior Court issued a number of detailed and careful rulings. We lost some of those rulings. They lost some of those rulings. We lost a $5.1 million monetary judgment. We lost an injunction, which isn't enforced today, preventing Axsun and Volcano from merging until April 2014, requiring the destruction of all Lightlab documents, and enjoining Volcano from receiving or using trade secrets, 3 trade secrets that the jury found were misappropriated. This is the conduct that Mr. Berman was referring to. We have paid the judgment. We have not sought appeal.
That was
from
attorney's fees? Was that what that was?
it was largely attorney's fees. It was a stipulated amount of $200,000 for certain lasers. Then there was a
Or
93
point
add-on
something or
with
another
attorney's fees.
attorney's fees?
But I think the critical point is that for those portions where we were found liable, we have not pursued an appeal. We have paid the judgment, including attorney's fees. We have complied with the injunction. There has been no merger. There has been no allegation of any breach of the injunction during the 2-year period that this appeal has been pending.
But I take it there's also been no continuing relationship between Axsun and Lightlab, at least development relationship.
Well, yeah, an important distinction. To the broader question, there has been a continuing relationship. We have continued to supply lasers just as we are required to do. There is no requirement in the contract that there be an ongoing development relationship. And in fact, in one of the Superior Court's opinions, post-verdict, she specifically said, this is not an issue that the jury decided. So the contractual obligation that the Superior Court determined to exist, which was that Axsun continue to supply lasers through April 29th, 2014, has been complied with. There hasn't been a suggestion that we haven't. And as the court knows from the briefing, there's ongoing litigation in other courts between the parties. What we've been doing, what they've been doing, has been fully subject to discovery by each of us during the 2 years that this case has been pending and briefed before this court. There's been no allegation that we haven't complied with the contract, that we haven't complied with the injunction, and we in fact have paid the judgment. Importantly,
Speaking of the permanent injunction, what is the proper legal ruling? Must one show use to justify a permanent injunction, or is the intent to use or the substantial risk that it will be used enough?
Your Honor, there are two parts to the answer to that question. And if I could, one goes to the substantive liability for misappropriation of trade secrets. The other goes to irreparable harm. And if we consider the Superior Court's decision from the outset on summary judgment, she put it to the parties, is statutory misappropriation, common law misappropriation, the same? Does one have an intent to use requirement where the other doesn't? And concluded basically that they were the same, that the intent to use of Chapter 93 is basically the same as the improper use under the common law standard.
Well,
Then we get to Justice
so
Botsford's
improper-
questions.
Okay, improper use then therefore does mean intent to use? Is that what you're
No,
saying?
I think, Your Honor, what happened on, if we go to the post-trial proceedings, and if I could break it down into two parts. If we could focus on trade secrets 1 through 5, the court was considering two things. It was considering the substantive question of, has there been a misappropriation of trade secrets? That does require a use. But she also considered whether you've proved a substantive violation, there might be evidence of an intent to use, which would justify a permanent injunction. And she did both at that point in the proceeding. The reason that that's not a big issue between us is because she didn't consider both. And what she really was considering is
She did consider both.
on claims on secrets 1 through 5, I don't think there's any real disagreement between us. And to go to Justice Gantt's question, what she was doing is determining whether there was a substantive misappropriation, step 1, and second, whether there was an intent to use that would justify an injunction one way or another. The debate comes when we get to the summary judgment proceeding and the events that follow. And this is where I think the Superior Court's words help us the most. The summary judgment proceeding is by definition one that goes to liability, to the substantive misappropriation claim. And if you read her opinion, that's what she was deciding. And she said to Lightlab on multiple occasions that at this point I'm considering the substantive liability question.
But this is post-jury. I don't understand. I mean, I thought that what you were talking about was a damages trial.
No, Your Honor, I think there are two issues, and I apologize if we conflated them.
I'm sorry, I probably missed.
The damages trial would go to damages for liabilities that had been established in the jury verdict. That was 3 different trade secrets. That was the breach of contract.
So this is about the injunction.
Yeah, this is, if the way I've thought about it, if it helps at all, is there are actually 33 trade secrets. There were 3 that were tried to the jury, and those were tried and determined. There was relief granted. There is the question of whether they should have been able to put on damages proof of further harm. There is then the other 30, and there's just an equitable proceeding for those. No one sought damages on those. So because it's a separate proceeding, that requires you to determine both the substantive liability claim and the question of irreparable harm. And what the Superior Court said when she got to trade secrets number 6 through 30 is, I'm having a summary judgment proceeding. I'm having it in part because of what I just decided on trade secrets number 1 through 5. But even if I grant summary judgment of no misappropriation, I will still hear you on whether there's a need for an injunction to prevent further misappropriation. And she said it at A12052. She actually said explicitly, and I quote, I still think that we are at a different juncture right now. That may be the argument you make on the entry of the injunction, but it's not the argument to defeat summary judgment. And she repeated it at A12045. So what happened, to go back to Justice Gant's question, is this. Having decided both the question of substantive liability and irreparable harm on claims on trade secrets 1 through 5, she then turned first to the liability question on trade secrets 6 through 30 and said, I find no misappropriation. Now, an injunction still could enter, given the determination of liability before. You could find that there was no use, but there was an intent to use that might have contractual or other implications. But she did not. She then had a proceeding where Lightlab both submitted a very broad injunction and had the opportunity to offer any additional arguments on the question of intent to use, or as I think about it, irreparable harm. They offered nothing, and she entered her final judgment.
Can I ask you a question as to this procedurally? If it was on summary judgment and it's on an established record, and we need not defer to any findings that the judge would make because it's inappropriate to make findings on summary judgment, isn't that right?
Well, Your Honor, I don't think she was making findings. What she was doing on, there are two parts again to this. On summary judgment of the substantive misappropriation claim, you certainly review that de novo. If she found undisputed facts, and you found them to be undisputed, both you and the Superior Court would determine the legal issue on the same substantive facts.
And
But
this is the
on-
one as to which that she apparently made some plea to the appellate courts to take a look at this because she's not sure she's right.
Your Honor, she was very careful and very consistent all the way through to say, I know this is complicated, I know the stakes are high, I know
But
that
it's in the
gonna go on.
context of this summary judgment that she was making that comment, isn't that right?
It's true, Your Honor, but the summary judgment ruling itself is not on appeal. There has been no appeal of the substantive determination that there was no misappropriation. The only appeal is on the question of the injunction, and on that, she is entitled to make factual findings. That's, in fact, her obligation to make factual findings.
Didn't she use summary judgment, though, as the basis for the injunctive relief?
Actually, Your Honor, she made it, that was the basis for determining whether there was a substantive violation. But if you consider what she said at A12042 through 12045, you will see that she was very careful to say, and I understand that you still may claim you're entitled to an injunction beyond the injunction I've given already. And if you want to make that argument, make that argument. But it's not appropriate at the summary judgment proceedings. She then gave them the opportunity to make that argument. She gave them the opportunity to offer more evidence. They offered nothing beyond what she had seen when she denied the injunction for trade secrets 1 through 5, and so she denied the broad injunctive relief.
Going
I
back
could-
to the expert, can we go back to the expert
Sure.
for a minute? I mean, all of your complaints seem to be exactly what cross-examination should bring out.
Your Honor, that is the argument that's made any time there's been a Daubert ruling. If we consider what this Superior Court was confronting, to capture it in 2 sentences, Lightlab was claiming between $89 million and $150 million in lost profits. Sentence 1. Sentence 2 is, Lightlab had never made a profit, ever, and
But that's never been a bar to evidence about where they were in their business cycle and what the likely prospects were?
Well, actually, Your Honor, if you look at the cases that we've each cited to you, one of the primary determiners of cases where lost profits can go and be subject to the crucible of cross-examination, and those where they can't is when there's a track record of some substance. And here, there are two critical missing components. They had never made a profit, ever, and as of the time of the briefing to this court, they could not identify a single sale that had been lost. And if the court considers the cases beyond just Massachusetts we've cited to the court, you will see that those are the important factual determinants.
So a company that is in the development and sale of a state-of-the-art technology that hasn't yet made a profit can't sue for lost profits?
Your Honor, it can, but that's not the circumstance we have here. And again, this is a circumstance where I think the Superior Court was very careful. On this Daubert motion, it's important to remember we lost some and we won some. The Superior Court held that for the period through April 29th, 2014, for lasers in existence, they could put on, Lightlab could put on its damages claim, so long as they subjected Mr. Clark to a voir dire to ensure the integrity of his projections. There was nothing that prohibited them from putting them on, and
But that's
we lost
peanuts
that.
compared to what they were claiming, right?
Well, Your Honor, what the court was doing, I think, is looking at that portion of his opinion that had some grounding, both historically and in facts that came from Mr. Clark. For the post-2014, to go to Justice Cordy's question, Mr. Clark, the CFO, even if voir dire provided nothing, his projections stopped in 2013.
But I think that Lightlab argues that there were other people who were going to talk about where the development was, and you said that one of the things the judge did that you said was one of the issues on appeal was, did she abuse her discretion to keep out testimony about future developments, right?
By Mr. Weinstein. And this, Your Honor is correct, but this is where the reference to the offer of proof is critically important. The people that were referred to, these other people that's been referred to in the briefing to you and in the offer of proof, may I finish the answer?
Please do.
Okay. Those people never talked to Mr. Weinstein. Now, if the court has in mind Mr. Berman's agreement, and I agree with him, that for this type of lost profits, you need an expert on the stand. The only expert was Mr. Weinstein. The people, and one of the reasons that the court commented upon the offer of proof in the manner in which he did is, the people that they're now telling you would have filled the gap, Mr. Weinstein never talked to. So if you consider the very narrow issues where she said you can't prove your case, a laser that's never been designed, never been developed, never innovated, never on the market, and sales that go out past 2014, sales that are assumed to occur only because, even absent a contractual obligation, customers are going to re-up every 6 years.
Well, I don't think I don't think Lightlab agrees to that formulation, does it?
Well, Your Honor, whether Lightlab does or not, that was the Superior
he
Court's
said?
formulation. And she was very, if you look at her opinion, she was very careful to say, I specifically have questions about the revenue reduction percentages, which is what extended beyond 2014. What the Superior Court did here, we believe, and again, we're not coming to you as the normal appellee saying, we won, we're happy to go home. We lost a fair amount, and we're not appealing. And even on this Daubert motion, we won some, we lost some. The portion that we lost is not before you for one simple reason. On the Saturday night before the voir dire, we got notice that Mr. Clark wasn't going to testify. If he had, that issue might be before you. He didn't, so the only issue is post-2014. Thank you.
Thank you, counsel.
Submit a Rule 22C letter to address some of the points that Mr. Lee raised with respect to procedural chronology and Weinstein's discussions with the so-called gap fillers.
Of course, you may do that, and then Mr. Lee can respond to your letter as well. Thank you.